Many business owners treat contracts as a formality. They focus on price, scope of service, and signatures, but they often overlook the hidden legal and commercial risks and inside the clauses. A contract is not just a paperwork, it is a risk allocation document. Some risks are not obvious at the beginning because parties are all friendly. The problem usually appears when payment is delayed, work is incomplete, expectations change, or one party wants to exit the contract. A good contract should not only record the deal, but also protect the business when things go wrong. One of the most common mistakes that I see is when the scope of work is unclear. What business owners think that the other party understands what needs to be done, but assumptions are dangerous in business dealings. If the scope is vague, both parties may later have different expectations. Here are some of the points that you can consider. You have to define exactly what work needs to be delivered, state what is explicitly excluded from the service, include deadlines, milestones, standards, and approval process, and clarify whether additional work will be charged. Another common mistake I see is that when there is a one-sided termination clause, many business owners do not pay enough attention to how a contract can be legally terminated. So a termination clause is important because it determines when a party can walk away, what notice must be given, and what happens after termination. So some of the key points here is that you have to decide whether either party can terminate the contract or only one party can terminate such contract. How many days notice must be given to the other party? Can the contract be terminated immediately if there is a serious breach? Or even what is a serious breach? And also another point is what happens to unpaid invoices after termination? Or what confidential information documents must be returned? Having a one-sided clause could be a risky thing to include in the contract, but it really depends on the party's intention when forming and before signing the contract. Another clause to consider is the payment terms. Business owners should look carefully at the payment clauses because cash flow is one of the most important parts of the business relationship. A contract should not only state the amount payable, it should also explain when the payment must be made, how it must be made, what triggers the payment, and what happens if the payment is delayed. And if it is delayed, whether there's any late payment interest attached to the invoice. So some of the key points that I would urge parties to consider is whether payment is to be made upfront, by milestones, or upon completion. Is there a clear due date for your payment? And is there a right to terminate your services if the payment is delayed or the payment is withheld? Another clause is confidentiality and use of business information. Contracts often involve sharing sensitive information such as pricing, customer lists, business strategies, supplier contacts, trade secrets, or even internal documents. And business owners should make sure that the contract properly protects the confidential information. Some of the key points I would urge business owners to consider is what information is considered confidential and who can access such information. How long does the information or confidentiality obligation last? And what happens if the confidential information is leaked or misused or shared to other unauthorized third parties? All these things can be properly documented in a contract, and provisions such as penalties or damages can also be included for breach of confidentiality. Another clause to consider is liability and indemnity clauses. So these are some of the clauses that business owners often skip because it sounds too legal or too technical. However, liability and indemnity clauses can decide who bears the loss if something goes wrong. So in simple terms, liability is about responsibility. Indemnity is about one party agreeing to compensate the other for certain losses. So some of the key point suggestions or key terms you can consider in your contract would be: are you responsible for losses caused by the other party? Are you required to indemnify the other party for broad or unclear losses? Is there a cap on such damages? Or are there indirect losses, loss of profit, reputational damages? So I can give you an example here that, for example, if you bought a certain amount of goods from your supplier to be delivered by a certain date to your warehouse, but the supplier promised to deliver it by January, but the goods were delivered only in March, a 2 months delay. Unfortunately, for the 2 months delay, you have lost multiple sales. It affected your business reputation. Does your contract cover for such undue delay from the supplier? If your contract covers it, for example, there is a specific compensation clause, then yes, you can claim damages from your supplier for the delay in delivering the goods. But if the contract is silent on it, it would be rather difficult and you would have to go to the court to prove that such delay caused the losses and whether the losses were foreseeable losses and whether they were not too remote. And then you can kind of get into a technical argument and proving the correct evidence. What I'm saying is it's just much easier to stipulate and specify all these things in the contract rather than to leaving it to chance in the courts. Another mistake I see is that when clauses do not match the actual commercial terms. So sometimes business owners use template contracts or copy clauses from previous agreements. The risk here is that contracts contain terms that do not actually reflect the commercial terms of your current existing transaction. Some of the key points to consider here is that the contract may refer to the wrong services, the payment structure may not match the actual commercial terms that both parties initially agreed on, the responsibilities may be outdated or irrelevant, the contract may include clauses that are too broad, too narrow, or simply unsuitable for the commercial terms intended by the parties. The business owners may accidentally agree to obligations that they never intended to. Template contracts are not always bad, but they must actually be reviewed and amended according to the actual transaction and reflect the intentions of the parties entering into the contract. So actually, in summary, a contract may seem like a very technical or legal document, but actually you do need to understand every clauses and provisions in a contract, but more importantly, you need to pay special attention to the key clauses of the contract that makes the business transaction or the business deal works or doesn't work. I think the most common thing for me is typically the obligations of both parties, the potential exit clauses or termination clauses, and thirdly, payment terms. These are the three main clauses that I would pay special attention to in any commercial contract. A good contract does not guarantee that there will be no dispute, but it can put your business in a much stronger position if a dispute occurs. So if you found the content today helpful, please do like and subscribe for more content like this. It would really go to help the channel and produce more videos like this.